Excellent. Let's go on the record in the matter of Marks v. Sunny's Rooftop Bar. My name is Judge Lipschutz. I'll be presiding today. A reminder to witnesses and jurors not presenting before the court to keep your audio and video muted. It's okay, we can have both attorneys up here right now. At this time, I'll ask for announcements and appearances from counsel, starting with counsel from the plaintiff.
Good afternoon, Your Honor. DeVico Khanna on behalf of the plaintiff. Today, I'm joined by my second chair, Ishi Nair.
Good afternoon, Your Honor. My name is Ishi Nair, and today I will be serving as the plaintiff's second chair.
Good afternoon, counsel. Defense?
Good afternoon, Your Honor. My name is Grace DeVico, counsel for the defendant, Sunny's Rooftop Bar. Today, I'm joined by my co-counsel, Ashlyn Tucker.
Good afternoon, Your Honor.
Ms. Tucker will be helping me with displaying exhibits as well as timing throughout today's trial. Your Honor, before we proceed with opening statements, the defense has some preliminary matters to address.
Sure. Why don't we start with the plaintiff first, and then I'll certainly come back to you and have a chance to fill in what you may. So Ms. Kashani?
Yes, Your Honor. Khanna,
I'm sorry, I forgot. And thanks for correcting me.
So firstly, we'd like to ask that all of the witnesses be pre-sworn.
Granted.
And secondly, we'd like to ask about your preference for screen sharing. Would it be okay if we have demonstratives and exhibits to just share them freely throughout directs and opening statements?
Sure. So this is what you may assume. You could share them freely, just make a record of what you're doing. If you are sharing something such as an exhibit that has not yet been entered into evidence, you can assume I see it, opposing counsel sees it, and the witness sees it. However, the jury just sees a blacked out screen while that's happening. When you enter into the evidence and assuming it's granted, I will unblack the screen and the jury is then able to see it as well.
Thank you, Your Honor. Nothing further.
Okay. Ms. DeVico?
Yes, Your Honor, we just ask that if at any time you can't see or hear me or my witness, that you just let us know.
Absolutely. And I'll ask the same from counsel. If for some reason you can't hear me, please let me know as well.
Your Honor, with that, the defense is ready to proceed with opening statements.
Okay. Very well. Let's move into openings. A reminder to the jury to switch to speaker view. And with that, I'll turn it over to counsel for plaintiff.
Yes, Your Honor. Just one moment. I need to get the timer up. Okay. Sunny saw that she was drunk, but he kept pouring and pouring and pouring. Good afternoon, Your Honor, members of the jury. DeVico Khanna on behalf of the plaintiff. On the night of March 24th, 2019, Jessica Marks tragically died. She went to a bar, drank at the bar, got into her car, lost control of the wheel, and tragically died in a ravine. Today, members of the jury, we're here because Sunny Mehta, owner of Sunny's Bar, ignored their responsibilities to ensure that something like this didn't happen. Members of the jury, we're here today because of something called the California Dram Act, a law that states if a bartender sees someone obviously intoxicated, if they see someone exhibiting the signs of a typical intoxicated person, and they continue to serve them alcohol, then the bar is liable or at fault for any of the damages that may come from that. Now, to do that, we need to prove three things. That first, Jessica was obviously intoxicated. Secondly, the bar ignored this and served her anyway. And thirdly, that Jessica died because of the actions of the bar. Now, today we will show with a preponderance of evidence and show that it is more likely than not that this was the case. In today's trial, you will hear from Morgan Levin, Jessica's best friend, and Sunny Mehta, clearly acknowledging the fact that Jessica was displaying symptoms of a clearly intoxicated person. Yet still, the bar owner, Sunny Mehta, kept pouring and pouring and pouring. You will hear that Sunny Mehta saw that she was stumbling, yet still poured. You will hear that he saw her speaking loudly and incoherently, yet still poured. You will see that she saw that Jessica was slurring her words, yet still poured. And you will also hear that after a night packed with drinking, Sunny Mehta knew that Jessica wasn't intending on driving and still poured another drink and let her into that car. Today, we will meet our burden and prove that Miss Letta is liable for the death of Jessica Marks. Your Honor, because of Miss Mehta's clear lack of responsibility and clear ignorance to the California Dram Act, Miss Marks is suing Sunny Mehta for wrongful death. Because not only did he see the signs of intoxication, she acknowledged them, yet still chose to ignore them and kept pouring and pouring and pouring. During today's trial, it's important to remember that Jessica was just 19 years old. She was barely out of school. She was a college student who went out drinking to have fun, but unfortunately died. And now we obviously can't bring her back, but we can do our best to make sure that those who didn't do anything to stop her, even though it was their responsibility, take accountability for their actions. Find Sunny Mehta liable.
Thank you, counsel. Counsel for defense, do you have an opening statement you wish to give?
Yes, Your Honor. May it please the court. She knew what she was doing. The plaintiff will have you believe that the night of March 24th, 2019 started when Jessica Marks walked into that bar, and that she was helplessly at the mercy of the workers there. But members of the jury, before Miss Marks even stepped foot into that bar, she knew how that night would go. Knew that no matter what the risk, no matter how many drinks she had, she would be driving home that night. And because she didn't show any signs that she was drunk to the servers at the bar, the risk she took became reality. She knew what she was doing. Jessica Marks' death is a tragedy, and the fact that she made poor decisions that night doesn't make it less so. But the plaintiff has a burden to prove their case by a preponderance of the evidence. Now, they just told you that Sunny saw the signs, she was drunk, but she kept pouring and pouring and pouring. But just showing that Jessica Marks had a lot to drink that night isn't enough to meet their burden. They had to show that the bar knew she was too drunk to have more, that they served her anyway, and that was a substantial factor in causing her death. That the evidence you'll hear today won't support that allegation, because they won't be able to prove that the bar knew Miss Marks was obviously intoxicated. But that isn't the only reason you'll find that Sunny's bar isn't responsible. You're going to hear about something today called comparative negligence. Although it may be a little uncomfortable, we're going to ask you to look at the decisions that Jessica Marks made on March 24th and determine whether those decisions caused her death. And if we show you more likely than not that her death was caused by her negligent decisions, then you can't find Sunny's bar responsible. Here's how we'll show you that Jessica Marks knew what she was doing that night. First, she arrived at the bar before arriving at the bar, she had 2 glasses of wine. And then you'll hear, after having that wine, she drove herself to that bar. Number 2, after arriving at that bar, she drank more. Over the course of almost 3 hours, Jessica Marks ordered drink after drink for herself. Wine, seltzers, beers, shots, and 3. The most heartbreaking choice Jessica made that night. You'll learn that once again, Miss Marks decided to drive herself home when she didn't have to. Her friend begged her to get into an Uber with her and leave her car behind. When she said no and made her own decision, she knew what she was doing. Members of the jury, at the end of today's trial, the evidence will be clear. Jessica Marks knew what she was doing on March 24th. Although it may be a little uncomfortable, we're going to ask you to look past the emotion we all feel and examine the facts of this case under the law. When you do, we'll ask you to find Sonny's Bar not liable. Thank you.
Thank you, counsel. At this time, I would remind the juror members to switch into gallery view to be able to see the attorneys and witnesses on the screen. With that, I'll turn to counsel for the plaintiff and ask if they have any witnesses they would like to call at this time.
Yes, Your Honor. At this time, we call Miss Morgan Levin.
Ms. Levin, you may take the stand and you may proceed when you're ready.
Yes, Your Honor. Now, before I begin, I just want to say we're going to be talking about your friend, Jessica Marks. I know this might be hard to talk about, so please let me know if you ever need a moment.
Thank you.
Could you please introduce yourself?
Good afternoon. My name is Morgan Levin.
And what is it that you do for a living?
Well, right now I'm studying forensic biology at UCLA. I'm also a barista at Starbucks on the side.
And how are you related to today's case?
Well, Jess was my best friend. I was with her the night she died.
Could you tell us a little bit more about Jessica Marks?
Well, we actually met in middle school. We bonded over our love of true crime podcasts. That's actually why I'm studying forensic biology. She decided to go more of the pre-law route. I really miss her.
And so what happened that night, the night of March 24th?
Well, Jess and I were celebrating our last night of spring break together, and we decided to go to Sonny's rooftop bar.
And what happened? What happened that night?
Well, later that night, Jess got in a crash and died.
Now, when you first arrived at the bar, did you notice anything different about Jessica?
When we first arrived, she seemed like her sober self to me. It wasn't until we were ordering drinks and got those drinks served to us that I noticed her acting differently.
So why was she acting differently? How so?
Well, after we ordered some drinks that night, she started acting differently in the way she talked, the way she moved, the way she looked.
And you were still served drinks after that?
We were served drinks throughout the entire night.
Now, I want to talk about how much you drank that night. At this time, let the record reflect that we're displaying exhibits on the screen, exhibits 11 through 16. Do you recognize these?
Yeah, these are pictures that I took of our table that night. I took them throughout the entire night, for social media.
Are they a fair and accurate representation of the pictures that you took that night?
Yeah, these are the photos I took.
Now, Your Honor, at this time, I'd like to enter these into evidence.
Any objection?
Nothing from the defense, Your Honor.
Okay, admit it without objection.
So let's walk through. What did Jessica drink in this first image? Oh, sorry, apologies. At this time, if it's okay, we're going to add the stipulated timestamps.
Any objection to that?
No, Your Honor.
Okay.
And so let's talk about what happened in this first picture. What did Jessica drink here?
Well, in that photo, you can see she has a glass of wine.
Now, Your Honor, if it's okay, would it be okay for us to put in visual representations of the drinks that Jessica Marks had that night?
I don't have an issue with it, and I assume if defense counsel has, but barring objection from defense counsel. So if defense counsel wishes to raise anything, I'm sure they will, and I'll take it up. But
All right.
barring that, you can proceed as you see.
So can we add a representation of the one wine glass that she had? In this second image, what did Jessica have to drink?
Well, you can see that bottle of wine, the decoy red blend, is ridiculously expensive. And she had maybe 2 glasses from that bottle of wine.
All right. And in this third image, what did she drink here?
Well, there's a can of beer and then a White Claw. She really liked those White Claws.
Let the record reflect that we're adding a White Claw and a can of beer. How about in this fourth image? What did Jessica drink here?
Well, you can see the 2 other mango White Claws that she got. She just really liked them.
Let the record reflect that we're adding 2 more White Claws. And now in these last 2 images, is there anything new that Jessica drank?
Nothing shown in the images. You can see the beer I had that night in the last photo.
And is there anything that you had that night that isn't pictured in here?
Yeah, near the end of the night, we were served these 2 green tea shots that were on special. So we were served those at the end of the night.
And Jessica had one, right?
Yeah, I just had one of those.
Objection, Your Honor. Leading.
Your Honor, may I respond?
Briefly.
I was just clarifying what the witness was trying to say. She said that they had 2 shots. I was just clarifying which ones Jessica had.
Sustain, why don't you rephrase your question?
Okay. And so is there anything in here that Jessica drank that isn't pictured?
Yeah, we were given 2 green tea shots and she had one of them.
And so how many total drinks did Jessica have?
Between everything, around 8 drinks that night.
And so how did Miss Marks's behavior change throughout the evening?
Well, as I said earlier, with each round we were served that night, Miss Marks began to slur her words, talk more loudly. Her eyes became red and watery. She was wobbly towards the end of the night. She even stumbled at one point.
Did anyone from Sunny's bar, any of the staff, witness this behavior?
Yeah, when Jess stumbled, she actually stumbled down the stairs. There's a stairway from the rooftop to the bar, right into Sunny Mehta, who's on the stairs.
Did anyone comment about her behavior?
Well, after Jess stumbled into him, Sunny said to his bartender, "We might need to cut this one off."
Did Sunny, the owner, actually cut Miss Marks off?
After that, he still served us drinks that night.
And did she say anything else, or did he say anything else throughout the night?
Well, there was this other
Objection, Your Honor. Vague.
I'm sorry, I missed the grounds.
Vague, Your Honor.
Okay, response?
Your Honor, we were talking about the comments that Sunny Mehta made that night, but I can clarify the question.
Okay, if you wish to withdraw and clarify, I'll allow you to do that.
All right. Did Sunny Mehta say anything else that night?
Well, aside from when he came to our table to serve us drinks, we did have one other interaction. At one point in the night, he pointed at Jess, looked at me, and said, "I hope this one's not driving home."
Did she do anything? Did he do anything about that after? Apologies. Did Sunny Mehta do anything after making that comment?
Objection, Your Honor. Vague. It may be heard.
Sure.
Your Honor, the opposing counsel's question was, did he do anything after making this comment? Your Honor, that's extremely vague. The witness could answer about anything in that topic. I would just ask that opposing counsel narrow down her question as to get a specific answer.
Response.
Yes, Your Honor. I feel like it's pretty clear with the line of questioning what we're talking about. After they made the comment was about, "I hope this one's not driving." I was referring to whether they did anything after stating, "I hope this one's not driving."
I'm going to the extent the witness feels she's able to answer the question, the witness can answer. And to the extent you feel you need to clear anything up additional on cross-examination, you'll have an opportunity to do that. So objection is overruled.
So did Sunny do anything after making that comment?
Well, I remember that Sunny kept on serving us after that and let us walk out of the bar at the end of the night without really saying anything to us.
And I'm so sorry that I have to ask you this, but what happened when Miss Marks left Sunny's?
Well, I decided to take an Uber. Even though I asked her, Miss Marks, Jess, she decided to get in her car, probably made it 1,000 feet where she crashed. Jess died that night.
No further questions, Your Honor.
Thank you, counsel. Any cross-examination for this witness?
Yes, Your Honor. Ms. Levin, I know this might be hard for you, but I'm going to have to ask you some questions about March 24th, 2019.
All right.
Now, let's talk about the decisions your friend Jessica Marks made that evening. Now, you arrived at Miss Marks's Airbnb at 7 or 8 p.m.
Right. You wanted to have a glam sesh before going to the bar that night.
Well, while you were there and having your glam sesh, you also started drinking, correct?
Objection, Your Honor.
Grounds?
Under the grounds of character evidence and relevance, firstly, relevance, it's irrelevant whether they were drinking before they went to the bar, because the case is about whether or not Sunny Mehta saw them exhibit symptoms while they were at the bar, and therefore any drinking that they did before that is irrelevant. And as for character evidence, any drinking that they did before the night could be used to influence what happened during the night, and therefore should be inadmissible.
Okay. Response?
Your Honor, as to the relevance objection, the defense's contention today is that Jessica Marks had planned the entire night out, that she had already planned to drink and drive. Your Honor, this is showing that she did plan to drink and drive. It goes to Miss Marks's plan.
Okay. And anything else to add on relevance, or does that cover that as well?
Your Honor, as to the character evidence objection, it is the fact that this witness, or Jessica Marks and this witness, were drinking before is relevant to this case. It's not showing that because she did it before, she would do it again. It's just showing that her plan for that evening was to drink and drive. And that's what she did twice.
Any reply, Ms. Khanna?
Yes, Your Honor. The fact that she had drank and then driven can be used as character evidence for the fact that at the end of the night that she chose to drink and then drive.
I'm going to overrule the objection and let us line a question.
So, Miss Levin, you started drinking at the Airbnb, correct?
I think we both had a glass of wine, maybe two. I'm not sure.
Well, that's right. You remembered Jessica Marks having 1 or 2 glasses of wine.
That's right.
After having that wine, Miss Marks drove you to Sunny's bar, correct?
Yeah, we wanted to go to Sunny's. We heard it had a great view.
Even though she had planned on drinking more that night, she didn't call for an Uber?
Well, she had gotten a rental car, so she decided to drive me and her to the bar.
And she drove you to the bar herself. She didn't call an Uber. Is that a yes to my question?
Yes, she didn't call an Uber.
She didn't call a taxi either.
No, as I said, we took her rental car.
That's right. Miss Marks decided to drive herself to that bar.
Yeah.
Now let's talk about the decisions at the bar. Now, when Jessica Marks was ordering for herself, you never ordered any drinks for her, correct?
We both ordered half and half, but when it got to our table, that was a different deal. She had most of the drinks that we ordered.
Well, is that a yes to my question? You didn't order any drinks for her?
I guess I'm kind of confused. We both ordered about the same amount, but she ended up drinking more than me that night.
Miss Levin, I'm not asking whether she drank more than you. My question is, did you ever order, say, a White Claw for Miss Marks and not yourself?
I don't think I did. No, we just ordered half and half.
Miss Marks chose those drinks for herself?
Well, we ordered them half and half. So yeah, she chose to order those drinks when we were served them. Yeah.
Objection, Your Honor. Speculation.
Can you expand?
Yes, Your Honor. The attorney keeps asking about what Jessica's intentions were or what her decisions were or who she chose to buy these drinks for. The witness has really no personal knowledge as to what Jessica's intentions were when she bought these drinks, whether she bought them for herself or for Ms. Levin to share.
Response?
Your Honor, I'm not asking this witness about the intentions of Miss Marks. I'm asking her what she saw. I'm asking her what Jessica Marks chose to have, which can be seen. She used her rationally based perception to see that Jessica ordered this drink, therefore she chose it.
Brief reply?
Yes, Your Honor. The question that opposing counsel asked was, did she choose these drinks for herself? Now, the witness has no personal knowledge whether or not these drinks were for herself or for them to share or for someone else.
Objections overruled.
So Miss Levin, she chose to drink those drinks, correct?
Yeah, we were served a lot of drinks that night, and she did drink them. Yes.
And you told us on direct about some stuff that Sunny Meta was saying. But you'd agree your memory of that night isn't perfect.
It was a couple of years ago, but I do remember those interactions.
Well, in addition to that, you were also drinking?
I had a glass of wine, a beer, and a shot. Not as much as Jess, but I did have some things to drink.
You would say you were definitely buzzed.
Right. Not drunk, but a little bit buzzed.
But you also weren't truthful on the night of March 24th.
I'm not sure what you mean.
Well, you used a fraudulent identification on numerous occasions that week?
Yeah, just bought a stupid fake ID for our spring break trip together. We did use a fake ID that night.
Well, you used it at Sunny's bar, that's correct?
Right.
And you also lied to police that night.
I don't really remember what happened right after the accident, but I remember being quite shocked from what happened. So maybe I wasn't as truthful to the police as I could have been.
Well, when you talked to the police officer, you told him that you and Jessica Marks hadn't been drinking at all that night. That's correct.
I was in shock. I did say that.
And that was a lie?
Yeah, we did have some drinks that night. We were served a lot of drinks that night.
So let's move on to the choices Jessica Marks made at the end of the evening. Now, you both left that bar at 11:45 p.m.?
Yeah, quarter to midnight.
And you had ordered an Uber, correct?
Yeah, I did.
You tried to get Miss Marks to take that Uber with you.
I begged her.
But she said she had gotten really good at a big night out. Isn't that right?
I regret not bringing her in the Uber with me every day. She did say that.
Instead of getting into your Uber, she made her own decision and got into her car, correct?
At that point, she got into her car. Yeah.
And as you got into your Uber, she started the keys and left. Isn't that right?
Yeah, I saw her crash.
Thank you. Your Honor, I have no further questions.
Thank you, counsel. Does that raise anything for redirect?
No, Your Honor. No further questions. May this
Thank-
witness be excused?
Yes, you may. Thank you for your testimony, Ms. Levin. Is there any further witnesses from the plaintiff?
No, Your Honor. At this time, the plaintiff rests.
Okay. Plaintiff having rested. Defense, do you have any witnesses you'd like to call?
Yes, Your Honor, the defense would like to call Sunny Meta to the stand.
Okay, Sonny Meadow, you may take the stand, and you may proceed when you're ready.
Good afternoon, Mr. Meta.
Good afternoon.
Would you please introduce yourself to the members of the jury?
Sure. My name's Sunny Mehta. I used to own a bar down in Malibu, right along the beach, Sunny's Rooftop Bar.
Well, I'd like to get right to the point today. Do you know why you're in court?
I do. A couple of years ago, we had a young woman come into our bar, and when she left, she got into a car accident. It's horrible.
And why is that important to why you're here?
Well, after her name was Jessica, after Miss Marks passed away, her mother filed a lawsuit against Sunny's Rooftop Bar.
Do you know what day Miss Marks died?
I do. It was March 24th, 2019.
Did you know her well?
I didn't know her personally. She was a customer who came into the bar, but I got them a table. I took their orders.
Well, before we get into the details of that night, I want to get a sense of your qualifications as a bar owner. Are you trained to know when someone's intoxicated?
Absolutely. I take what I do as a bartender very seriously. I've been trained by the state to identify symptoms of intoxication.
Well, how do we know when someone's displaying these symptoms of intoxication?
Sure. Now, there's a wide range of symptoms that someone can display, and it varies from person to person, but it could be anything from watery red eyes to loss of balance, even vomiting.
Well, then let's talk about whether or whether not you saw those signs in Jessica Marks on the night of March 24th, 2019. Do you remember what time she arrived?
I do. She came around 9 o'clock when our dinner service was finishing up.
And from your observations, when Miss Marks arrived, was she exhibiting any of those signs of intoxication that we just talked about?
She was not.
Did they order any alcoholic drinks from you?
They did. I took their orders and I brought them back their drinks.
So how many times would you estimate that you were at that table?
Well, I took their orders 4 or 5 times. I'd take their orders and then I'd come back with their drinks. So 8 or 10 times that night.
Well, at any point during those 8 to 10 times, did you notice Miss Marks displaying any signs of intoxication?
No. When I'm talking with my customers, I'm looking for those symptoms, and I just didn't see them on Miss Marks that night.
Would you have cut off Miss Marks if she did display signs of intoxication?
Absolutely. That's what the law tells me, and that's what I do as a bartender.
And Mr. Mehta, you heard in Morgan Levin's testimony today that you were there when Jessica Marks supposedly fell down the stairs into you. How do you respond to that?
I'm sorry. That just didn't happen.
Well, let's talk about Miss Marks' decisions at the end of the night. Now, what time did both of them leave your bar?
Well, I remember they signed the check around 11:40 that night, and then they were probably out of there by 11:45.
Did you know how Jessica Marks was getting home that night?
I did. I had a conversation with her, and she told me she planned on driving home.
Well, did you see Jessica and Morgan Levin as they left your bar?
I did. I saw them walking down the stairs, and that's something I look for, again, as a chance to see if they're intoxicated. If Miss Marks stumbled down those stairs, I'd be concerned, but she didn't.
Well, did you ever see Miss Marks' request for an Uber on her phone?
No, I never saw that.
Did you ever see her call for a taxi?
No, I never saw that.
Did you see her get into the Uber with Morgan Levin?
No, she told me she was going to drive, and that's what she did.
Thank you. Your Honor, I have no further questions.
Thank you, counsel. Any cross-examination for this witness?
Yes, Your Honor. Now, Mr. Mehta, you're a convicted felon, right?
No,
You didn't steal a $3,000 TV?
no, I never stole a TV. There was this one time very long ago, I purchased a TV that was stolen.
And therefore, you're a convicted felon, right?
Yes, sure.
Now, I'm sure that you're aware if today you're found guilty, you might have to pay a substantial amount in damages, right?
I'm aware of the lawsuit that's been brought in front of me.
Is that a yes to my question?
That's correct.
Now, I want to talk about what happened that night. You were the only one taking orders, right?
That night, I usually like to chat with my customers, see how they're doing, so I take their orders. That's right.
And you were the only one who was serving alcohol that night, right?
Right. That's correct. I was serving the drinks, and Frankfurt, one of our bartenders, was downstairs making them.
Now, I want to talk about how much you served to Jessica that night. Do you recognize this exhibit?
I do.
What is it?
This is a receipt we make as a part of my bar. You can see we got Sonny's Rooftop Bar on the top, and you can see Morgan Levin sign that.
Is it a fair and accurate representation?
Certainly.
Now, using this exhibit, let's talk about the drinks you served. You served a whole bottle of wine, right?
That's right. That's that Decoy red blend. It's the cheapest wine we got. It's 31 bucks.
3 hard seltzers,
That's right. Those are those White Claw cans at 27 bucks.
and 2 beers.
That's
Right.
right. Sorry, I didn't mean to cut you off. We got the Ballast Point IPA and the Sierra Nevada.
Objection, Your Honor. Hearsay, if I may be heard.
Sure.
Your Honor, I don't believe this exhibit has been entered into evidence today. Therefore, opposing counsel reading off which drinks are on this exhibit is hearsay. It's an out-of-court statement.
Apologies, Your Honor. I forgot to admit it into evidence. I would, after laying the foundation, okay, may I offer this exhibit into evidence?
Okay. Any objection to the admission of Exhibit 17 into evidence?
Well, then, Your Honor, I would object to lack of foundation.
Okay. What foundation do you believe is missing?
Well, Your Honor, this is Morgan Levin's receipt, as you can see on the bottom of it. So there's a lack of foundation as to this witness and knowing what this is. Your Honor, he can say it's fair and accurate, but this is not this witness's receipt.
Your
He
Honor,
didn't sign it.
Let Mr. DeVico finish, and I'll give you an opportunity to respond, Ms. Khanna.
He didn't sign this receipt. Morgan Levin did.
Response.
Yes, Your Honor. Firstly, I'd like to apologize for interrupting. At the bottom of this receipt, you can see merchant copy. To my understanding, Sonny Mehta was the merchant. So this is his copy of the receipt.
May I be heard, Your Honor?
Briefly.
Your Honor, if that's the case, I would just ask that opposing counsel lay that foundation, that this is the copy he received.
Why don't I'll give you an opportunity to lay a little foundation, and then you can remove this into evidence.
Now, this is your copy of the receipt, right?
That's right. I made this receipt and I gave it to Miss Levin that time.
And now in total, there are 9 drinks on this receipt, right?
It sounds right.
And there were only 2 people at this table. Oh, apologies. Your Honor, may I offer this into evidence?
Any objections now?
Because of the foundation that was laid, we have no objection.
Okay. Exhibit 17 is admitted.
Now, there were only 2 people at this table, right?
That's right. Morgan Levin and Jessica Marks.
And there weren't a lot of customers that night. Is that right?
It was one of our quieter nights. Saturday night was a bit busier, but we had 10 or 12 people there.
Jessica Marks was 5 feet tall, right?
I'd say she was around that tall.
110 pounds?
Sounds about right.
Objection, Your Honor. Speculation.
Response.
Your Honor, the witness has previously stated that she was about 110 pounds. Furthermore, by looking at someone, the witness could approximate how much someone weighs just by looking at them.
Brief reply.
Your Honor, we just asked for a limiting instruction to the jury that when the witness says that she was 110 pounds, he found that out after the fact, that he didn't know that at the time, because, Your Honor, you can't tell how much someone weighs just by looking at them. That's a fact that was learned in the autopsy.
I think a degree from his rationally based perceptions could speak about weight to a degree, so I'm going to overrule the objection.
Yes, Your Honor.
So was that a yes to my question?
That sounds about right. That's correct.
You served a 110-pound, 5-foot girl 9 drinks, and you didn't think she was drunk?
Objection, Your Honor. Argumentative.
Overruled.
You didn't think she was drunk?
Counsel, that's not true. I didn't serve one person all of those drinks.
Now, I'd like to talk about the training you've obtained to see these signs. You know the signs to look for when someone is drunk, right?
Absolutely. That's part of my role as a bartender.
These signs include slurring,
Slurring their words, that's right.
talking loudly,
That can be true, yeah.
stumbling and fumbling,
Right, loss of balance is quite prominent.
and a lack of hand-eye coordination.
Yeah, that kind of goes along with the loss of balance, that's right.
They include someone speaking incoherently.
That's true.
Now, if you were to see these symptoms, you would have to stop that person. You would have to stop serving that person, right?
That's likely true. Again, you can't just do it based on one of these symptoms. It's kind of a judgment call, but that's probably true.
Now, did you watch Exhibit before today's trial?
Pardon me, which exhibit?
Exhibit 10, the video that Morgan Levin took of Jessica Marks?
I believe I was shown that in my deposition, that's right.
Was that a fair and accurate representation of the video? Is this one on the screen right here?
This looks to be what I was shown earlier, that's right.
And this video is stipulated to be posted at 11:11 p.m., right?
I don't know when this was posted, ma'am.
Well, based on the stipulation, it's posted at 11:11. And Miss Marks entered your bar at 9 p.m., right?
That's right.
11:11 is towards the end of their night.
It's about 2 hours and 10 minutes later.
And you interacted with her 8 to 10 times?
That's right.
In this video, she seems to be slurring her words, right?
I wouldn't say so, no.
Now, could we play the video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Your Honor, at this time, we'd like to offer Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. Hearsay, if I may be heard.
Sure.
Your Honor, this witness, our opposing counsel, just played this video before it was entered into evidence. Now, it has to be played after, or else all that Ms. Marks just said is hearsay, Your Honor. It must be entered first. I'd ask that we strike all of the testimony from this video that was played before it was entered.
Your Honor, may I be heard?
Sure.
From what I understand, whenever we displayed evidence before they were entered, they'd be blocked out from the jury. And furthermore, we're not using this video for the truth of the matter. We're using it to show her state of mind at the time. So not so much what she's saying and what she's saying means, but the symptoms that she's displaying that one can see.
Response?
Your Honor, if they're solely entering it for that purpose, then I have no objection to it being entered. I just have an objection to the fact that it was played before it was admitted into evidence.
What I'm going to do is I'm going to admit it, and the initial playing constructively would not have been heard, but for the sake of time, we can consider now that it's admitted, it has been constructively played to the jury after the fact.
Yes, Your Honor.
And so it is your testimony that she wasn't displaying any of the symptoms of being drunk?
First, let me say that I never saw this behavior from Miss Marks, but I don't think they're drunk in this video.
So it's your testimony that Miss Marks isn't displaying the symptoms of someone who is drunk?
It's possible she might be drunk, but I can't conclude that from this video.
No further questions.
Thank you, counsel. Any redirect for this witness?
Yes, Your Honor. Mr. Mehta, as opposing counsel just talked about Exhibit 10. Now, were you around when this video was recorded?
No, I wasn't.
And have you seen it? Did you see it that night?
No, no one ever showed me that video. I only saw it when I was deposed earlier.
And did Jessica Marks ever display any of the behavior that she displays in this video to you?
Absolutely not. From what I saw of Miss Marks, she was sober that night.
Thank you. Your Honor, I have no further questions. May this witness be able to step down?
Any recross?
No recross, Your Honor.
Thank you for your testimony, Mr. Mehta. You may step down.
With that, Your Honor, the defense rests.
Okay. The defense has rested. With that, are we ready to move into closing arguments?
Your Honor, the plaintiff is ready.
Okay. Defense, you ready as well?
Yes, Your Honor.
Okay. Okay, I'll turn it over to counsel for the plaintiff for closing arguments. And just a reminder to switch into speaker view so you can see the attorney on the full screen. And with that, the floor is yours, Ms. Khanna.
Yes, Your Honor. Sonny saw that she was drunk, but he kept pouring and pouring and pouring. Good afternoon, Your Honor, members of the jury. Tavisha Khanna on behalf of the plaintiff. On the night of March 24th, Jessica Marks tragically died. All because a bar owner didn't do his job, all because Sonny Mehta saw the signs and ignored them. All because Sonny kept pouring and pouring and pouring. You heard today that Miss Marks was served one whole bottle of wine, 1, 2, 3 hard seltzers, 1 beer, and a shot. He poured 8 alcoholic drinks. Members of the jury, the defense keeps claiming that Sonny is supposedly trained. However, members of the jury, if he was trained, how didn't he notice that Jessica was drunk when she walked into the bar? How didn't he notice that she had been drinking all night? Your Honor, owning a bar comes with a responsibility. Responsibilities that Sonny Mehta ignored that night. Now, there's no doubt that Sonny Mehta didn't see her drunk. He visited that table 8 to 10 times. There weren't that many people there. He said that himself. Now, today when Sonny Mehta was on the stand, we saw the same symptoms occur when you are drunk in the video of Jessica that night. Sonny Mehta sat on that stand and said that she could have been drunk. Therefore, it is more likely than not that she could have been drunk that night. We heard today that Sonny Mehta made not 1, but 2 comments about how drunk Jessica was that night. We might need to cut this one off. He said, we might need to cut this one off. He knew that she was so drunk that they needed to stop giving her drinks. But what did Sonny do? He kept pouring and pouring and pouring. He said, I hope this one's not driving. He said, I hope this one's not driving. Sonny Mehta knew that she was so drunk that she wasn't fit to drive. But what did he do? He poured another round of drinks. Your Honor, he saw she was drunk. He acknowledged she was drunk. He commented on the fact that she was drunk. But he kept pouring and pouring and pouring. Jessica Marks is 19 years old. She's 5 feet tall, 110 pounds. It's completely unreasonable for us to believe that she made these decisions to go drunk and driving. Jessica had been drinking for a long time. And it's unreasonable for us to believe that she went with the intention of drunk driving. And it's unreasonable for us to believe that Sunny Mehta missed the signs that she was drunk. It was unreasonable for us to believe that he thought she was sober after a whole night of drinking. Sunny Mehta is a convicted felon. After the conclusion of today's trial, he might be paying damages. And so it's unreasonable for us to believe that a convicted felon whose livelihood and income depends on the conclusion of today's trial is unreasonable for us to believe him. Today, the plaintiff has proved with a preponderance of evidence that it is more likely than not that Sunny Mehta knew that Jessica was obviously intoxicated under the grounds of the California's Dram Shop Act, which specifically states that bars are liable for the injuries that they cause by overserving. Now, we ask you to find Mr. Mehta liable for Jessica's death because he saw the signs, he acknowledged the signs, he knew she was drunk, but he kept pouring and pouring and pouring.
Thank you, counsel. Defense, do you have a closing argument?
Yes, Your Honor. May it please the court. She knew what she was doing. Jessica Marks knew Sunny's bar wasn't going to babysit her. She knew that the servers at the bar wouldn't be watching her every move, every moment. She knew it was a risk walking into a bar as a 19-year-old, but she also knew she could get away with it. So when Jessica Marks chose to get drunk at that bar, she knew the servers might not notice. She knew what she was doing. Now, the plaintiff has asked you to believe that Sunny's bar is responsible for the death of Jessica Marks. They tried to tell you that Sunny's bar saw the signs, but that they kept pouring and pouring and pouring. But members of the jury, how is Sunny Mehta supposed to know that someone is obviously intoxicated if it's not obvious? The servers at the bar that night couldn't possibly have known what Jessica Marks's blood alcohol content was. Now, the plaintiff wants you to assume that Sunny's bar is responsible, but in fact, Jessica Marks knew what she was doing, and they had to prove that to you by a preponderance of the evidence. So what evidence did they present? A 30-second video. 30 seconds out of almost 3 hours of time. A video that literally captured 0.3% of the time that Jessica Marks spent at that bar. And not only that, it was 30 seconds that my client wasn't even there to see. The plaintiff is asking you to assume that 30 seconds tells you all you need to know about 3 hours. You know better. Now, the plaintiff also has tried to say that Sunny Mehta is trained. So why didn't he see the signs? But members of the jury, they have it backwards. Sunny Mehta is trained to look for the signs. And when he saw Jessica Marks, he concluded there were no signs to look for. Now, if you agree, if you think that the plaintiff hasn't met their burden, then that's as far as we go. Case closed. But if you do believe that the plaintiff has met their burden, then the judge is going to be asking you a second question. Because we've raised an affirmative defense called comparative negligence. That question will be, was Jessica Marks's death caused in whole or in part by her own negligence? Today, we've met our burden in that regard. because we've shown you that Jessica Marks knew what she was doing from beginning to end, and that she made 3 careless decisions that cost her life. She drove, she drank, and she drove again. Number 1, she drove. The plaintiff's own witness told you that before they even stepped foot in that bar, Jessica Marks had already decided she was okay with drinking and driving. After consuming 2 glasses of wine, she drove herself to that bar with the plan for a big night of drinking. No designated driver, no Uber. She knew what she was doing. Which brings me to the second decision that Miss Marks made. She drank. No one ordered for her. No one forced her to drink anything. She ordered round after round, knowing that she was going to be driving home. Which brings me to decision number 3, her final decision, the fatal decision. Because members of the jury, the Uber was right there. She didn't even have to call for it. Her friend literally begged her to get in that car and leave her own car behind. She said no, made her own decision, and just moments later, her car was at the bottom of a ravine. Members of the jury, this case has always been about the choices of Jessica Marks. And that hurts. It feels better to take the plaintiff's route, to try desperately to find something someone else could have done. If the bar had cut off Jessica Marks that night, would she still be alive today? Maybe. But that isn't the question you're here to answer. The plaintiff wants you to blame my client for failing to step in when the truth is, he was never given a reason to step in. And all that the plaintiff wishes my client Jessica Marks certainly knew the risks, knew the danger. She knew what she was doing. We ask you to find the defendant not liable for the wrongful death of Jessica Marks. Thank you.
Thank you, counsel. Any rebuttal from plaintiff?
Yes, Your Honor. She knew what she was doing. Members of the jury, she was 19 years old. She was drunk that night. Why do we have the California Dram Act in place? For these situations, for when someone who is drunk, for when someone is unable to make their own rational decisions, there's someone else who's making sure that they're safe. The bar is the one that's at fault. She didn't know what she was doing. She was drunk. She was 19 years old. And Your Honor, members of the jury, it's unreasonable for us to blame this on Jessica. Thank you.
Thank you, counsel. With that, the case will be submitted to the jury. I'll work on finishing up my ballot as well as will the jurors. When they have their ballots ready, if they could just shoot me a message so we know that we're good to go.